Hey, welcome. It's Dave Brannen here. We're here for Ask a Lawyer Live, Thursday edition. Today is the day where we answer people's questions live on the air. I'll put the phone number up here soon in case someone does want to call in. If no one calls in, I'll answer questions that people put in the comments. You just have to type them out in the YouTube comments and I'll see them and I can answer the questions that way as well. Um, I'll also probably be answering questions on our, I feel like I'm going to sneeze here, right in the middle of allergy season. So I've been suffering here all day. I'll answer questions from the forum, the disability forum. I'll go on there and see if there's some questions to answer there. And also, there was one thing I wanted to discuss today before we get into the people phoning in around the topic of workplace surveillance. We talk here a lot about insurance companies doing surveillance of you um, when you're outside your home and all these things for an insurance claim, but I had a talk with someone today, a potential client, about the issue of workplace surveillance, and they were wondering whether this is something that is legal to do. Um, they kind of got in trouble with their work for basically opposing it on behalf of other employees, and I think it's an interesting topic. So, to what extent can employers put surveillance cameras in a workplace? Not sure if anyone here wants to offer up their thoughts. If you can type it in the chat, if you know anything at all about this topic, I'd be interested to get your take on it. So, what's the deal? Can employers just put cameras everywhere? What can they put them? Because it's common. You go somewhere, you'll see cameras outside, you'll see cameras in the lobby. But can employers put cameras like in the back areas where the public doesn't go? Just sort of watching the employees, keeping an eye on them. What are the situations where employers can do that? So the starting point for this is that employers certainly can use video surveillance in a workplace, but in Canada, employees are entitled to a right to privacy, and so the employer, when putting in video cameras, has to balance legitimate business purposes with the right to privacy for employees. So this is a delicate balance, and employers, it's not something where employers can act rashly and just put in cameras. They want to think this through quite a bit and be very measured in their approach on how they do this. Now, the general rule is that if employers are going to put cameras in private areas, so not in the public areas, they're going to be more in the private areas, then that is something where they will need to tell employees, and also they will have to make sure that it is minimally invasive. All right. So let's take a look here. So the rules that apply with this type of situation would come from the PIPEDA is the name of the law. We'll look at that in a second. This is the privacy laws that affect Canada-wide. Some provinces have their own versions of this, but if a province doesn't have its own privacy laws, then the PIPEDA laws will take effect. So when can employers do surveillance? Basically, they can do surveillance in situations where they're trying to do for a legitimate business purpose. Things that have been recognized as legitimate business purposes would be things like preventing theft, ensuring safety of employees or customers, and sometimes even investigating specific allegations of misconduct. So if there is some indication of theft from either employees or outside people, then surveillance can be used in a workplace for that purpose. Now, even if you're an employer and you're trying to root out some kind of theft thing that's going on, you have to be very cautious with using hidden cameras. Almost always, these are going to run afoul of privacy rights to put hidden cameras. So there would have to be very credible evidence of misconduct in order for an employer to be justified in putting hidden cameras. And that would have to be a situation that was very narrowly done and tailored to an investigation. So something employers would want to be very careful about, or when using hidden cameras, and would want to do it with legal advice. Now, if the cameras are not hidden, so it's acceptable that employees should be notified of the cameras, but courts have seen a difference between cameras that are in public areas versus private areas within the workplace. So it's quite permissible and accepted by the courts that employers can have a legitimate business purpose for having cameras in the lobbies, in the public areas of whatever business you're at. But private areas, and again, there's different levels of private areas. The most private areas like washrooms, changing rooms, these spaces would be have a higher expectation of privacy than anywhere else, and it would be pretty much prohibited for an employer to have cameras in those areas. Now, less private areas would be like people's workstations, their office, and again, there would be expectations there of some level of privacy. So employers would have to have a very good reason, a good business purpose to have cameras there. And just wanting to like generally monitor employees is not seen as a legitimate business purpose. So there'd have to be something else that employers were going on. Certainly, employers would be well advised to have a workplace policy around any use of surveillance within their, video recording and surveillance within their business, especially in the areas not accessible to the public. That policy should set out the purpose of it, why they're doing it, how it would be used, how long the footage is kept. Employees should be advised that it's going on. And that in those situations that would help. If the employer had that type of a setup, it's more likely to be accepted by courts. If they just sort of decide they want to start recording people and have no policy or do anything like that, then it could be a situation where they could be getting themselves into problems. Also, employers can kind of get in trouble if they are taking all this footage and then not securing it and it gets released to the public, or somehow people get a hold of this private footage, and that's just another headache that they're going to have to deal with it. They're not allowed to just have videos of their employees and have it open to the public for viewing. So they will have to have a policy on how to store and destroy this type of information over time. Now, if you're concerned about surveillance in your workplace from video cameras and the like, you can bring it up with your employer. And the next step would be to file a complaint with the Office of the Privacy Commissioner of Canada or your provincial privacy commissioner, depending on which one would be in charge of your situation. And if you're unionized, you could certainly file a grievance, and it would have to go through your union to see if the surveillance is allowed under the collective agreement. All right, it's very interesting. Now, if you want to learn more about this, let me just bring this over here. There we go. Let me share my screen. If you want to learn more, I'm not going to read through all this, but it's just somewhere you can go. You can go to the Office of the Privacy Commissioner of Canada, and they have a whole section on their website here dealing with workplace privacy. Because in this day and age, it does go beyond, like I'm talking just about video recording in the workplace, but there can be other things like digitally recording what you're doing on your computer. Certainly, audio recording would also have a host of problems. A lot of video recording is just going to be silent video and not audio recording. You get into a whole nother host of problems if you are recording not just video, but also the audio of the conversation. So that also becomes a problem. This reviews just some of the basic law around privacy in the workplace as an employee and the kind of things that employers have to keep in mind. Okay. You can just Google that. If you Googled privacy in the workplace, you'd find this article pretty quickly. They give tips for employers on how to. So if you were wondering, just look through this and see, has your employer followed these types of recommendations before implementing this workplace privacy? If not, then it's likely they have not gone about it in the wrong way, and it could be a problem for them. Certainly, if you are fired for raising concerns around privacy and your employer has not followed any of these kind of recommendations, that again doesn't bode well for them. Might mean that this was a wrongful dismissal on your case. All right, you just remove that. So let's jump into some questions if anyone has them, or sorry, phone calls if people want to phone in. We'll try. We've had mixed results with this phoning in because I am not super technical with this, and I have had to kind of hack together a system, but hopefully it's worked the last couple times we've done it. So if you do want to phone in and ask questions live on the air, There's only a few things I would indicate if you're going to do that. So number one is you have to make sure whatever local thing where you're watching this is muted. Otherwise, we're going to get this weird echoing feedback. Also, there's a tape delay with YouTube. So even though this is live, they still have a delay. And it's going to confuse you if you're talking to me on the phone and on your TV. If you're listening to it, it's going to be me like 5 seconds ago. So it's going to sound off. And so you do have to mute it if you're going to come on live to talk. All right. If you want to come on live to talk, just maybe put it in the comments. I'm going to go look at some of to see if we have any questions in the forum right now. And if I see someone puts in the chat they want to come on live, then I'll stop talking about the forum stuff and we can dive in. So I'm going to share my screen again. So I like to answer the questions on the forum. This is a great time for me to do it. The forum is this is the Canadian Disability Claim Forum. It's designed for people to be able to get their questions answered by others who are dealing with these kind of problems. I like to monitor it. Certainly I moderate it. So if there's comments that are, it doesn't happen that often, but if people are making comments that others are, we really try to keep it to be a positive place. It's not really intended to go on and criticize people, even sometimes if they may, criticism is warranted. It's just not the place for it. So I would encourage you just to keep it to positive comments. Don't pry for too much information from people. Just try to answer their questions based on what they're asking rather than asking for more information or giving judgments, judging them based on what they're saying. So try to avoid that. But let's see what we have here. So someone has got employer asking to talk on the phone. So this person is saying they're on LTD, past the 2-year mark, and they're in the process of applying for CPP disability, as I don't know when and if I'll be able to go back to work. My employer has emailed me asking to get on a call to discuss an organization change. I was given a specific time for the call as well, but only given 2 hours notice. Oof. That's not a lot of notice. I don't know what the change is, but I'm sure they're downsizing. I have a good extended healthcare benefits, which I don't want to lose. I'm thinking I should avoid a video call as I don't know what impression I would give compared to when I was working. I also don't know whether they may think I look good or sickly or whatever else. So here are my questions. Should I get on a call with them or just have them email me the details? If I get on a call with them, what do I tell them when they ask how I am? And if they offer me a settlement on the phone or email, how would I respond? All right. We can answer these questions. So let's copy these. All right. So first question. Should I get on a call with them or have them email me? So it's a personal choice whether to get on the phone or ask for an email, but I would suggest doing the phone call if that is what they are asking for. Okay. So question 2. So I would say do the phone call if that's what the employer is asking for. This person's obviously very anxious. So let's talk about this. So if I get on the call with them, what do I tell them about how I am? You don't have to give personal medical details to the employer. You can say that you are still not capable of return to work at this time. And you don't really have to give more details beyond that. If they press for information, tell them to write with their questions and you can get your doctor to give answers. So it's good to just put it off on your doctor to give information, because a lot of it, if it's medical things, then you can have your doctor answer to some extent, like what your impairments would be, what type of accommodations you would need, that kind of thing. Now, if they offer a settlement, you never have to answer on the spot. So if they terminate you or offer a settlement, you can ask for time to consider it and to get legal advice. They must give you reasonable time to do so. The employer will expect that you need time to consider it, discuss with family, and to get legal advice. There you go. So I'm going to just post this answer. There we go. There. All right. It's an easy one. Let's see what else we got here. Oh, yeah. This is one we asked a few days ago. Yeah, there's really no changes here on that one. And I don't see any other. Looks like there's no other new questions. So I've never been so up to date on answering questions on the forum since I started doing it on this podcast or this TV show. It just keeps me up to speed here a lot better. There's really like unlimited. There's infinite amount of questions and things on here. Some of them quite repetitive, but that's fine. There are just so many things. I don't respond to all of them. Here's a question. Hi, everyone. Does it signify anything when the insurer approves beyond the change of definition and states that benefits will be paid until age 65? What can I expect after change of definition approval? So change of definition approval refers to long-term disability insurance benefits. When you move beyond the period where your disability is approved for your own occupation and it gets into after the 2 years, you get with a lot of these plans, it's called change of definition. So the disability definition goes from own occupation to any occupation, which is a harder standard to meet. This person wants to know, like, once they get past that and they've been approved for any occupation, will they just be paid until age 65? That is an open question. It doesn't mean that you automatically will be paid from till age 65. Every long-term disability plan is subject to ongoing proof of disability. So normally what will happen is after you get into the change of definition, they will start asking for annual updates and these kind of things. And if there's no changes, you might just continue to be paid forever. If there's changes, then they will, they could do more investigations and things like that. Says here, I have another one. If anyone has knowledge regarding, I would love to hear, is one permitted to rent out rooms in their home while on LTD and CPP? So will that be considered active income? Yeah. So generally, yes. Generally, you can rent out a room is not going to rise to the level of an income, but the further you get away from renting out a room in your house towards having a rental property, so that you're managing the further you're along that spectrum, then it can be considered work. If you're a property manager, so the question is, are you a property manager or are you just an investor? A simple room in the house is usually not going to trigger this, but if it goes beyond that, the closer you get to like managing a property, then that's when you're going to get into trouble. All right. See if we can do one more here. Let's find one that people want to have an answer to. If you see one here that you want me to answer, just put a note in the messages there. Let me see here. Here's one. Whoops, what happened to it? Must have clicked on the wrong button. Here's one here. So this person needs some advice. My wife, who has a disability affecting her back, was working full-time but had to stop for 3 months. She then tried returning to work 3 days a week but couldn't. Now she's working 1 day a week, and that is sometimes difficult. She earns about $500 a month. So that's 5,000. That's 6,000 per year. I believe that's right. 6,000 a year. Yep. She was on LTD for 2 years, and now the insurance suggested that she apply for CPP disability. Given her situation, can she apply for CPP disability while working this limited schedule? Yes, she can. I don't think anyone's ever answered this poor guy, so I'm going to answer it. Okay, so the thing here is they're going to look to see, like, does she have capacity to earn more than 500 a month? Because she has gone up and down, and they'll want to look at what were the reasons that made her reduce it to 500. Are they still there? Has her condition improved? Is this just the thing where it's up and down? And so they will want to look to see if she can earn more than 500 per month. If they're satisfied that she only has capacity to earn 500 a month, then yes, you could be approved for CPP disability while earning only 500 a month. The trouble is if they think that it is indication that she has some work capacity, so there's a higher bar to prove with Service Canada that you can't work more than what you're doing. That'll be what it is. So they will look at it carefully to determine if she has the capacity to work more hours and could deny on that basis. Yeah. Done. All right, well, let's see if we can find another question here that nobody's answered. I feel bad when someone asks something and doesn't hear back. Let's see if I find another one. Here's one that looks like it was never answered. Yeah, no, it wasn't. From March. Oh boy. Maybe it wasn't a question. Let me just see here. I was recently approved for CPP disability and I'm on LTD through work. I'm working 5 to 6 hours a week as it helps my mental health. Now my LTD is still checking and CPP wants to put me back on a work trial. My mental health is cyclical and I haven't been able to work regularly for 6 years or more. My concern is because my mental health is cyclical and in the warmer months I am somewhat stable, but in fall and winter I am not. They will take 3 to 4 months where I'm stable and deem me to be cured. And yeah. Okay. Yeah. So it's not really a question. I think that's probably why people didn't answer. They're just looking for people to comment on this. Well, what I would say here is, like, the insurance company must take into account your condition as it affects you over the long term. Like you are saying, you have good and bad months. This makes the situation complicated and you may have to work with the CPP to show that you continue to struggle with maintaining So one thing would be like, well, if she can only work in the good months, or he, I guess, if they can only work in the good months, then isn't that working? Well, not really. Like employers aren't going to keep you employed if you can only work certain months, unless that is like a seasonal job or something like that. It would make it quite difficult to be employable if you can't be dependable for the full year. So this would just be a very difficult case in terms of proving things, but it should be one that could be successful. But I could see it being difficult because of that. Alrighty. All right, we got a question here, so I'm going to go answer that. Let me just remove this. So Matthew's asking, let's see what Matthew's asking here. When do the CPP disability application? Oh, when you do the CPP disability application with your firm, what do you tell your LTD insurance provider when they ask when you appeal a CPP disability denial? We don't do a lot of applications for people who are with a long-term disability. I'll just be honest with you, because usually the insurance company will hire their own firms that they deal with to help their people in that case. But what would you tell the insurance? I would tell them you always are going to appeal. Like if you are going to apply for CPP disability and you think you could be eligible for it, you really should appeal right up until the final stages. It's in your interest, as we've talked about on here before, it's really in your interest to get approved for CPP disability if you can. Even if you're receiving long-term disability, it's still your interest to get approved for CPP disability. It will really help with your CPP retirement in order to get on CPP disability as early as you can. And you also the other reason you want to do it is most insurance companies only deduct the original CPP disability amount that you got when approved. They don't keep every year when you get a cost of living increase to your CPP disability, they will not deduct that. So over a number of years, you're going to get hundreds of dollars extra that the insurance company is not deducting. But that's a good question, Matthew. All righty. I'm going to probably check off here in a second if there's no one has questions. Just take an end of the workday. Now I'll be off tomorrow and I'll be off on Monday, so I won't be back until next Tuesday. Hopefully we'll see some of you folks here next Tuesday. Hope you have a good weekend, and yeah, I'll see you back here next Tuesday. All the best.